Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about L-1 visas in this set of videos, and one issue that comes up is what exactly is an employee for an L-1 visa? Well, a majority or substantial stockholder of a U.S. foreign corporation can be an L-1 employee. A sole stockholder can be an L-1 employee. A sole proprietor. So there's different definitions. Where the beneficiary is the owner or major stockholder, there must be evidence submitted that that person's services will be used temporarily and that that person will be transferred abroad upon completion of the temporary U.S. assignment. Now, what about compensation of the employee? Well, the employment does not necessarily depend upon the amount or existence of the salary, rather control over the employee's activities rather than the salary is the essential employment. Now, there was one example where it was not an abuse of discretion to deny the L1A where the salary was not commensurate with the managerial experience. So, if you send someone over that has 20 years managerial experience and pay them $5 an hour, obviously that will be denied. Now, the payment by the foreign or U.S. company, that's not material. Okay, whichever one is fine. There is no prevailing wage requirement in L1 petitions, as there are with H1Bs and a lot of others. So you just have to determine only whether the person coming in would become a public charge. So basically they need to make enough to survive and not become a public charge, and that should be sufficient. Now, a beneficiary which is employed in the U.S. by a foreign company who is not controlled in any way by the foreign company's U.S. office, that will not qualify for L1 status. So you do have to have the proper relationship and the proper documentation and show they won't become a prevailing public charge issue, and then that should be fine. Okay, more in the coming videos.